Okay, we can. Yes, yes,
Okay.
yes.
So, good evening, everyone present here today, and welcome again to the fourth class of our EMW second Pan India Classroom series. In our last class, our senior mediator and trainer, Mr. Shiv Kumar, not only enlightened us about the basic principles of mediation, but also elaborated on various terms like perception, conflict, dispute, which are and their relevance with the mediation. In the last class, I actually expanded upon the various facets of his versatile personality, and we all have learned and were enriched by the depth of his knowledge on the subject. We are extremely fortunate today to celebrate his golden jubilee as an advocate. Eh, nahi? Is it today?
50 is gold, correct.
So golden jubilee. So 50. So as he was enrolled today, 50 years ago as an advocate at Bangalore. Am I right, Chief?
Yes, you're right.
Yeah. So first of all, unmute ourselves and give a quick round of applause. Sanjanjan ji, 1 minute के लिए unmute कर देते हैं.
Thank you so much. Thank you.
So I would say there can't be a better way to celebrate this occasion when he will be deliberating and educating all of us today on the process of mediation. And I think Shiv also agree with me because he loves, imparting knowledge and teaching all of us. So he will be also very happy by celebrating his golden jubilee today with us like this. So with immense pleasure, I will invite him again today to further enlighten us on the process and stages of mediation. Now, the process of mediation traverses through the various stages. Each stage has its own relevance and is a key factor in the furtherance of mediation. Today, we will not only understand what those stages are, but also we will expound on their importance in the process of mediation. Now, before we commence today's session, I will invite our moderator, Ms. Samriddhi Saraswat, to set the ground rules for today's session. Over to you, Samriddhi.
Thank you, Reema ma'am. I hope I am audible. A very good evening to our esteemed speaker, Mr. Shiv, Reema Bhandari ma'am, Pushp ma'am, Tankanchan sir, and everyone present here. I am short of words to express how fortunate we are to have Shiv sir here amongst us. Once again, felicitations to you, sir, on completion of 50 years of being enrolled in the Bar Council of India. Please accept our immense gratitude on the occasion of Guru Purnima on behalf of everyone present here. Well, gurus are to be thanked every day, but today we are thanking you a little more. So I'm going to be the student moderator for the evening. My name is Samriddhi Saraswat, currently studying in the 8th semester of BBA LLB from GenNxt Vyas University, Jodhpur. Before we begin today's session, a small reminder to kindly keep your other gadgets muted. Keep your mics on mute unless it's your turn to speak, and try to keep your cameras on so as to make the session more interactive. Also, if you have any question, either write it in the chat box or kindly raise your hand so that our speaker can address the questions asked by you. Furthermore, if you have any more questions or queries post-class on today's topics, please forward them to me on my email ID as provided in the class invite. I'll forward them to Shiv sir and revert accordingly. Thank you. Over to you, Shiv sir.
Thank you very much. Thank you, Push. Thank you, Reema, and thank you all the students for the wonderful wishes on today. It is a great feeling to believe that you've actually passed 50 years at the bar. The only thing that I sometimes wonder is, it's 50 years not only at the bar that I practice in, but several other bars in and around Bangalore. That also has happened in these 50 years. That has been a part of the growth. Anyway, thank you. I told Push today, I sent her a message saying that this is the best possible way I could spend or celebrate the 50th year of practice. to be amongst students, to be amongst people who are eager to learn, to be amongst people who are willing to think, who are willing, not afraid to ask questions, because that is the best way to learn. All right, now having said that, the rules for today's session are the same as they were last time, and somebody has explained them to you. I have no issues if there are interruptions or interventions during the course of the presentation. Discussions are welcome. It will not be taken amiss. So with those basic comments, let me try and get to my sharing screen. Why am I not getting a full screen? Any problem? Somebody can help me? Okay. Let's begin with a basic precaution and a basic alert for all the students. When we talk about stages of mediation, or when we talk about the process of mediation, or the steps of mediation, please remember that all of us talk about all these put together. We have a habit, as I mentioned to you last time, of defining things in the perspective of what we want to describe or what we want to define. Therefore, whenever the word stage is used, do not get flustered. It could mean the same thing as process. It would also mean the procedure that you follow in the mediation process. That is all that it means. Now, before I proceed further, I think Pushp has sent you a small alert, which I designed, that we had requested you to revise the class 1, 2, and 3 that you've already had. I hope you have done that, because during the course of this presentation and towards the end, I am trying to link those 3 classes and get you guys to discuss something arising out of those classes and try and run a common thread through class 1, 2, 3, and 4. But you need not be, there will be no punishment if you have not revised it. We will go through the process again. Now, please remember that when we talk about the stages or process of mediation, there is a fundamental rule to this whole process. And the fundamental rule is that the mediator is in control. To use a very cliched expression, the mediator is the boss. To the extent that the mediator controls the process, the mediator controls the procedure, the mediator controls the behavior of the parties in terms of saying what should be done and what cannot be done. He controls the responses of the parties. But please remember that the outcome of the mediation process, if they want to settle, if so, on what terms do we want to settle, is entirely in the hands of the participants, namely the disputants. Therefore, when we talk about lack of authority of a mediator, we do not talk about the lack of authority to control the process of mediation. At the last class, you remember, mentioned to you that a mediator has no authority. That does not mean that the mediator has no authority to control the process of mediation. He or she has no authority to control the manner in which the dispute should be resolved. He or she has no authority to determine how and in what direction the resolution terms must happen. But he or she has certainly the powers to control the process of the meeting. It's like a chairman of a board of directors of a company. He controls the procedure, he controls the behavior, he controls what transpires at the meeting. But the end result is always left to the parties. Now, keeping this in mind, let's move on. I have placed this slide for one reason, because it's very easy to define what mediation is. And during the last class, I did make certain references to saying what mediation is not. Therefore, I'm refreshing it by pointing out to you that mediation is not a fact-finding process. Please remember that the process is not intended to find out facts of the case. Neither is it an investigative process. A mediator is not a police officer. He's not an investigative officer. He's not a domestic inquiry officer. A mediator does not investigate anything. He merely facilitates the process. Mediation is again not an interrogative process. Why do we say this? We say this because most of us respond when a party says that I did this. The first response of a person who's not a mediator is why. Therefore, interrogation at a mediation is impermissible. It's not a mediation process at all. And as you discussed last time, as we've seen last time, it is not an adversarial process either. It's not a blame apportioning exercise. Mediation does not apportion blame. Neither is it a judgmental process. We do not look at who's right and who is wrong. Neither is it an advisory process. Though, in the Chief Justice of India's speech at the summit, Singapore-India summit, he has suggested that a mediator's role be expanded to an advisory role. But as of today, it is not. Again, I caution you, mediation is not a truth-finding process either. A mediator is not concerned with what is the truth, because the concept of truth itself varies from person to person. I have brought this today to your notice because as we go along, and towards the end, as I mentioned, all these considerations will prevail when we discuss the last portion of this presentation. Please remember these facts. It's not a fact-finding process, not investigative, not interrogative. It's not a truth-finding process, not adversarial, no blame apportionment, no judgment, and not an advisory process. Right. Keeping this in mind, let's see what happens in the mediation process. Now, wherever you hold mediation, there is importance we give to the manner in which seating occurs. These pictures have been taken from a very high funda, high value mediation centers. It may not be possible to replicate this in the Indian context, but what these pictures are trying to suggest to you is that it must be a comfortable environment. It must be a non-invasive, a non-disturbing environment. The ideal situation for mediation is what you see in the second slide and the third slide. Now, if it is a round table, can you now tell me why a round table is preferable to the other one? Anybody would like to take a guess? The hint is already there on the slide.
Nobody dominates, sir. I mean, if they are sitting in the one chair in between, then I think they'll be like dominators.
Equality. What mediation says is everybody is equal to me. I don't care who you are, what you are, where you come from, whether you are a millionaire or a billionaire, I don't care. Therefore, to first sense of equality that a disputant comes into the mediation room is to say, wow, here is a round table, man. We are all equal. This is founded on the principle of King Arthur's Knights of the Round Table. Don't pay too much importance to it. If possible, try and manage seating which represents an equal representation, an equal status to all the parties. If not, then we manage with what we have. The next stage is the welcome. Have you guys ever seen a situation where litigants are welcomed to the court? That would be the day when I see a judge saying welcome, good morning to anybody. They don't even wish you good morning, leave alone welcome you. Now, when we agree that the mediation process is a non-adversarial process, it's a party-centric process where the stakeholders are primarily the disputants, we need to establish a difference between that adversarial process, between the court system and the non-court adversarial system. Therefore, we extend a warm welcome to the disputants. The purpose is to create an environment of cordiality, an environment saying that you are the disputants, you actually matter to us, you actually matter to the mediation process, rather than a nameless, faceless litigator sitting in the end of one court hall where it is completely impersonal. Now, what is the nature of the welcome? It is not what you see on your screen. That is why I put it there. The mediator is not going to jump about and hop about and scream and laugh and say, welcome, as though you're welcoming him to a Scotch party or a champagne party. No. None of those things that you see on your screen must happen when you welcome the parties to the mediation process. What is the content? The content, again, is adequate enough to make that party feel wanted. This is the criticality of the welcome process. You have to make the parties feel that they are wanted, that they are important, and that they are the primary stakeholders in the whole process. We insist on this welcome so that the trust and faith in the mediation process is enhanced, primarily because they do not witness these scenes, they do not experience these sentiments in a court of law or in any adversarial process. Right. Then comes the next stage of mediation, or the next stage in the process. There's an introduction, what we call. The mediator is required to know the disputants, is required to identify the disputants. You would probably, in court-annexed mediation, you would never have seen the disputants before in your life. You don't know who is the plaintiff. You don't know who is the defendant. You don't know who is the one who is who has raised the dispute. They are a pack of strangers who come to the mediation room. You are a stranger to them. And therefore, the prevailing environment, the prevailing atmosphere there is one of suspicion, is one of discomfort, is one of being in an environment where you feel strange. You're no longer in a familiar environment. And therefore, you seek the parties. And the first step that the mediator does is to ask the parties to introduce themselves. It is quite possible, and it has happened in court-annexed mediation, that the plaintiff and the defendants have never seen each other at all. Let's take the case of A, who has filed a case against B. Sometime during the course of the legal proceedings, A dies, his legal representative, son or daughter, comes on record. That son or daughter has never seen the defendant. And the plaintiff and the mediator has never seen any of them. Therefore, it is critical that the parties know whom they are dealing with, whom they are and who they are not. Introduction is also important because the party who claims to be Mr. So-and-so may not be Mr. So-and-so. There are cases where unauthorizedly parties come to the mediation process claiming to be Mr. So-and-so or Mrs. So-and-so. It may not be so. Therefore, the purpose of introduction is for the parties to identify each other, to understand that whom they are dealing with, and more important, for the mediator to understand whom he or she is dealing with. Now, when you request the parties to introduce themselves, the manner is very important. You will probably be finding people who want to talk about their entire life history when you ask them to introduce themselves. I don't know whether you have come across these people. In mediation, you say, Mr. So-and-so, would you please introduce yourself? And the introduction starts, I'm so and so, I'm the president of the Rotary Club, I'm president of the Lions Club, I have done this project, I have done this, I have done that. No, we are not interested in this. What you need to make clear and understand is, we would like to know your name, we would like to know what you are in this organization and whom you represent. And do you have the authority to attend this mediation session and resolve a dispute if we come to it? These are all the issues that are required when we talk about the introduction process. So this is in the control of the mediator. Now, you remember, you go back to the fundamental principle where I said that the mediator is in control. These are the areas in which the mediator can control. If one of the parties takes off, giving you a 4-page CV about himself, like politicians, for example, or like a big business magnates who come, you have the authority to say, that is not what I'm interested in. I would just like to know from you what you are, who you are, and why you're here. Period. Then comes the more difficult portion, the mediator's introduction. Please remember, the parties don't know who you are. I mean, if you go into the metaphysics and if you go into philosophy, probably you don't know who you are. That question you will get to know only when you're 89 years old and when Swamiji comes into your life and you go into meditation and so on and so forth. Keep that aside for a moment. Why does a mediator need to introduce? Because these disputants in court-annexed mediation have come from an environment where they are constantly in an adversarial relationship with everybody in the system. The litigants are the least important and stakeholders in the matter. So from a judge, a situation where there is a court hall and a judge sitting, whom they know, they have got used to, they have been with that system for 300, 400, 500 years. We're walking into a mediation room, then they see a stranger sitting there. They have no clue who you are. They probably believe, at least most of them do believe, that you are another judge sitting there trying to dispose of the case. So to dispel those doubts, to create an environment of cordiality, to explain to them who you are, what you are here for, a brief introduction of the mediator becomes necessary. They must know who you are, you must know who they are, the parties must know who they are, parties must know who you are. Now, what is the manner and the content? If you were to replicate the CV that the party gives about himself, if you were to replicate the same process about yourself, you have lost the mediation process. No party would be interested in finding out what you do in your life. All that the parties or the disputants are interested in is in understanding how competent are you to do a mediation? What is your mediation experience? Do you have any specialized subject expertise in mediation process? This is all that is required. There is no requirement when you introduce yourself as a mediator to go beyond what is formally required as an introduction. And it is not required for you to establish that you are the best person available for this, not required. The psychological aspect to this is when I'm trying to sell you something, when a person tries to sell you something, there is always the intent to impress. There is always an unidentified need to say, my God, the other person must think of me as being very competent. Now that psychological need cannot be interspersed with a mediator's introduction. So what we call a business-like introduction. How would you introduce yourself to a fellow lawyer? I'm so-and-so, I'm doing this, I've been a mediator for so-and-so years, these are my specializations, and I have dealt with cases of this kind for some time. That is all that is needed. So this will be the next stage. Now, at the end of this stage, you should have established an environment of cordiality, an environment of familiarity, if not too much of familiarity, but certainly a sense of pleasantness, a sense of cordiality, sense of comfort. It's like introducing or getting guests to your house. If you get 2 or 3 new guests to your house, what would you do to make them feel comfortable? Apart from offering you cannot offer the parties coffee or tea unless you have facilities for it, no problem. But the idea is to make them feel comfortable in the environment in which they are sitting. You could use English language, you could use Hindi, you could use vernacular, it doesn't matter how. Greet them, welcome them, make them sit down. So you have set the stage. This is called setting the stage for the mediation. It's like a play that you do. You have to set the props everywhere. Set it up, get the parties in, make them sit, and then you're ready to take them on in mediation. Then comes, what do you see on your screen here, on your left? What does that denote? Anybody would care to answer?
To open up, sir?
Yes,
To start.
Sorry?
To start or to begin.
Yes. What does this actually denote? This.
An open box.
Correct.
Where we are free to share our thoughts.
What is in it? Can you see my
Light. Sir, maybe it is a symbol of hope, like showing a symbol of hope.
Positive thing.
It is showing the way, showing the direction for a particular thing.
Right, very good.
That's the light.
What is the difference between this I'm showing you and this I'm showing you? There are 2 closed boxes here. There is one open here. Is there a difference?
Yes,
It is an open environment.
The closed box is that not able to tell anything. No, nothing is expressed, but openness is willingness to show the way and to come forward.
And somebody has raised a hand. Samriddhi, do you know who that is?
Sir, Ayush Tamrakar.
Sir, it's showing that there is a good 2 people who is not having a view to go further, but there some person is coming between those 2 boxes and show them the positive lights.
Very good. All right. This establishes 2 things to me. One, Vishal Kumar has raised his hand. Yes, Vishal.
So the closed box means that's something which they can't take anything, and the open box which can take something like ideas and all.
Very good. Very nice. I'm so happy. Now, can you guys go back to the last class? Mediation is all about what?
All about the willingness to come to a situation from both the ends, win-win situation. Like,
I showed you.
nobody is
All right.
superior or nobody is inferior.
I showed you. Wait. I showed you 2 slides last time.
Actively listening to the disputants.
2 slides to establish one principle of mediation. Do you remember? One was about 2 people standing with one numerical figure in it. You don't remember?
9 and 6, 9 and 6.
6 and 9. What does that represent?
Our view might be different.
Understand.
Others' view might be
Understand others' perspective.
Different
Perception.
perception.
Mediation is all about perception.
Perception, sir.
Now, these 2, the simple question I asked you, what does this represent? Look at the number of perceptions we got. Now, let me try and see whether I could relate it to what I'm going to talk about. If we say that this is a disputant and this is a disputant and this is the mediator, what is that mediator doing? That mediator is making an attempt to bring some light, to talk about something that will open up, that will give them information on what? On what the mediation process is. They have come in complete lack of knowledge about why they are here and what the mediation process is. So they are sitting here. Figuratively imagine them sitting here, and you open that box and light emerges. Light emerges to do what? To explain to them what the mediation process is. But that is too figurative. So the mediator has to move into what we call an opening statement. This opening statement could be used in several ways, in the sense that the terminology could be different. But before you begin the mediation process, it is incumbent upon the mediator to explain to the parties what mediation is. If you do not explain to the mediation what the parties what mediation is, they will be not only reluctant to participate in the mediation, they will be suspicious about what you're trying to do. It is in that context that this particular box has been used. I will tell you what the mediation is, and then you can decide whether to open or not open. So what is an opening statement? An opening statement is made by the mediator before any of mediation process begins, to explain primarily to the parties what the mediation process is. They have to be told that it is not based on authority. They have to be told that it is not judgmental. They have to be told that you're not a judge and you're therefore not capable or authorized to give judgments. They have to be explained. They have to explain to them what the concept of party autonomy is, what voluntariness is, how they can get away and walk away from the mediation process if they don't want to participate. You will have to explain to them what is the benefit of confidentiality, what it allows them to do, how confidentiality allows them to be transparent and open about whatever they wish to say, because nothing of what goes on will be revealed elsewhere. All the principles of mediation that we did in the last class will have to be briefly enumerated in your opening statement. Now, when do you do this? You do this before the actual mediation process begins, but after the introduction of the party and the process over. Question is, who does the mediation? Who does the opening statement? Obviously the mediator, it can't be anybody else. How do you do it? Is based on an individual style. What mediation requires you to do is to convey that information relating to the principles or fundamentals or jurisprudence of mediation to the parties in a manner that is understandable by them. If you are therefore talking to a group of rural people or a dispute between a management and the labor, and you use high funda English, Shashi Tharoor language, you've lost mediation. There is no way, I don't think even Shashi Tharoor understands what he's saying, but that's a different matter. Leave alone that. Therefore, what is the manner? How do you make this statement? You need to gauge the parties, which is why you have the introduction of the parties. You will form a basic opinion of what the parties are like, what is their level of understanding. And keeping in tune with that, you make an opening statement, explain to them what the process of mediation is, so that they are in no doubt about what they are doing here, why they are here, what can be achieved in the mediation process, and how it can be achieved in the mediation process. I will not go into details of the contents, except but to say that all the principles of the mediation that you have learned in your last class will have to be repeated here. If I go into it all over again, then we will not have adequate time to go through the rest of the presentation. So are we okay so far? Samriddhi, do we have any questions directly or indirectly?
Sir, we had one question which was asked just at the beginning of the presentation. Is that how would you mediate without knowing the facts? Because the first screen, somebody asked this question.
Where have I used the word facts?
So in the first slide.
Yeah.
A fact-finding process.
Right, very good. Now I tell you that I like my scotch with water. You dispute it and say, no, he never drinks it with water. Mr. Shiv Kumar drinks straight from the bottle. Now, what is the fact here? What is the fact?
The first statements are that you drink with water.
Yeah, with water.
It is a perception. You believe that I drink scotch from the bottle. I believe that I drink with water. Now, the investigative process will determine which is true, which is not true. Mediation is not concerned with what is true, what is not true. Therefore, I don't care what the fact is. Domestic violence case. A person says he is abusive. The other one says he is not abusive. A police authority will find out whether actually there has been violence or not. A domestic inquiry officer will indulge in a fact-finding process. Now, the fact in this sentence, if you replace by perspective finding process, you have gone out of the not. This not will disappear. Mediation then becomes a perspective analysis understanding process. Am I reasonably clear? Somebody please find out if the person who asked the question is satisfied with this answer or no.
Sir, I hope he is, because
he's off.
There's no response from his or her end right now.
All right, okay. So we look at the opening statement as opening the door to the mediation process. The job of a mediator is to get these two people also to open the lid and be able to receive the mediation process, take in the light that you're giving them, so that the mediation process moves forward. Opening statement, therefore, is actually the key to the mediation process. If it is not done in a effective manner, mediation will not proceed. But if you do it in a manner which creates trust, confidence on a one-to-one basis with the mediator and the parties, the disputants, and explain to them how this process is different from the adversarial process, how they are the first stakeholders and therefore that they are entitled to take decisions of their own. Party empowerment is what we call it. Then it is likely that this light will also find a place in these two boxes. Are we okay so far? All right. Now, the next stage in the mediation process is what we call a joint session. Now, imagine, go back to this slide, parties are sitting here, or here, or here. Let's say all the seats are full. All of them are sitting there. There you begin what is called a joint session. The parties are present. If necessary, their advocates are also present. And the mediator is in control of that meeting. There could be several attempts at disrupting that meeting. Some parties in court annex mediation are very, very competent at taking control of the meeting. by a variety of methods. They would want to be the bosses. They would want to control in which direction the mediation process will go. But the mediator has superior authority, has greater authority to control those proceedings. So now you get into a joint session. Parties, advocates, if any other representatives, and the mediator. Why do you need a joint session? You need it firstly to gather information, additional information. You need it. If you have a court annex mediation, then there are the court documents will be with you. You may or may not have read it. If you read it, fair enough. If you don't read it, fair enough. But in the joint sessions, in the presence of both the disputants and in the presence of the advocates and in the presence of the mediator, the party concerned is asked to talk, to speak, to tell you about what this case is about and why this person is in the mediation process. Because it's a party-centric process, the party is encouraged to speak. Now, can you tell me what happens when the party speaks quickly? Because we will be. Why? What is the advantage in the party speaking?
So they speak about the history of that case, so many things about the case.
All right, they speak about the case. Anything else?
They are showing willingness to for the dispute resolution when they are coming forward with a free will to sort out the issues between the parties.
Okay, fair enough. Anything else?
They are showing their perspective of this joining the mediation process.
Sorry, they are showing?
Perspective of joining the mediation session, sir.
All right. Again, the last slide we discussed. When a party talks at the joint session, he or she is conveying his or her perspective of that case. Remember, it is his understanding or her understanding of the case that comes forward, not the legal version. The legal version will come from the lawyers. What he will convey to you is what he thinks is his case or she thinks is his case. So you are able to get hold of information that is outside the framework of a plaint or a written statement for the purposes of proceeding with mediation. This is what you would probably call additional extra information that is not available to you within the pleadings of the parties. Second object would be to understand the disputant's perspectives, as I said. He or she may have a completely different perspective than what is reflected in the documents that are given to you. So your job is to understand the disputant's perspectives. Then it enables parties to understand each other's perspectives. For the first time, the parties who are in dispute at the mediation are face to face with each other on a dialogue-based platform and are asked to speak about their respective perspectives, which perhaps for the first time has been understood or listened to by the opposite side. The plaintiff everything is in his head, defendant, everything is in his head. Once the plaintiff begins to speak about his or her perspective, the same perspective filters to the defendant or to the opposite side. It may not result immediately in something. Something will go into his head and probably make him think or her think about, what is this guy saying now? Is this what he's trying to say? It enables the thinking process. Then, while this is going on in the joint session, it is up to the joint session. It helps the mediator to evaluate obstacles and possibilities. That depends on your skill. You will be mentally screening what is being said. And in that process, you will be imagining and thinking and analyzing what possible obstacles could I find in moving forward in mediation. How is this possible to move forward and see whether I can get a resolution? The strategy switch is switched on in your mind when you listen to joint session objectives. Okay, then it reinforces and revalidates the parties' position as stakeholders. When you ask the parties to speak first, the plaintiff speaks first, the defendant speaks afterwards, keeping the advocates in the background, keeping yourself in the background, it reinforces the fundamental basic jurisprudential principle of mediation, that it is the party-centric process. Parties are important here, nobody is important here. So at the end of the joint session, what is the state? The state is that the mediator has got information, from the parties, the information that the parties may want to reveal and not be compelled to reveal. They're not compelled to reveal any information they don't want to. You have heard the information, gathered information from both sides. You have understood what their perspective is about that dispute that they are trying to mediate on. You have initiated the process, started the process, ignited the process of the parties trying to understand each other's perspectives. You have at the back of your mind already started thinking about which direction shall I go. You accept thinking about how to hit them on the head and make them agree. You will be thinking about everything else as to how to sort them out. And then at the end of it, the joint session, parties should be able to believe. They should be put into a position, guided into a position where they begin to believe that they are important in this process. It is their process. It's a party-centric process. I am the boss is the feeling that they would go out with. Next. Thereafter, you get into what is called a private session. That's the next stage. You have heard both of them. Both parties have heard each other. Now the time comes to go deeper into the information that is being given. This private session happens with the parties individually, with or without their counsel. That choice is of the parties concerned. If they want their counsel, you cannot prevent them. If they don't want their counsel, you are free to have that conversation with them. Now, please remember, in private session, the objective is not to interrogate. In a private session, who is present? In a private session, there are only you and the party. You are not going to find out what is the fact. You are not going to investigate whether what she's saying, he or she is saying, is the truth. You are not going to interrogate them. You're not worried about the truth. You are not going to be passing judgments in your mind about what is being said is right or wrong. Neither is it. You are going to advise them. So what do you do in the private session? The private session is intended for the mediator by asking questions to understand the core of conflict. Now, quickly, what's the difference between core conflict and dispute? Quick. I will ask Push to give the person who answers correctly a chocolate. What's the difference between conflict and dispute? Please go back to class 1.
Sir, dispute arises from the conflict, and the conflict is the root of the problem.
Perfect. All right.
Dispute is a short-term process, whereas the conflict is the long-term.
Perfect. Try and include a definition there which says a dispute is a manifestation of a conflict. All right, if you include that. All right, Paulami, Push, you over a chocolate. Cadbury's. All right, okay. So the private session is to understand the core of the conflict. How is this done? How is this done?
By asking questions.
Excellent, by asking questions. What kind of questions can you ask?
Where did the conflict arise?
There you are. There you are. That is why I put this slide. Who, why, when, where, what? Prohibited. W question. The moment you say, how did it start? You're talking about a fact-finding process. The moment you say, why did it happen? It's an investigative process. It becomes an interrogative process. Did it actually happen? It's a truth-finding process. Remember this. Now you understand the relevance of this. So you ask questions. What kind of questions we'll come to a little later, but you're right. You have to ask questions. When we ask questions, there are things like open-ended questions. There are something called closed-ended questions. There are some things called interest-based questions, reflective questions. These will be done for you in detail. It's not possible to cover all these in 1.5 hours, but it will probably be done to you when you undergo training in mediation or in your class. So appropriate questions has to be asked so that the core of the conflict and dispute has to be met. What does mediation deal with? Conflict or dispute?
Dispute, so it's a dispute resolution system, right?
What does mediation do? What does courts do? What do courts do? A court deals with dispute. Mediation deals with conflict. Remember, we took the example of homeopathy versus allopathy. That
Yes,
allopathy
sir.
treats the symptoms, homeopathy goes to
Homeopathy
the
root.
core.
Yes.
That's right. Please remember that. Then the next private object of private session is to enable a venting platform. Remember that when parties come to the mediation table, they are in absolute tension. And therefore, the venting platform has to be provided by the mediator, which translated into simple language means a mediator shall keep his or her mouth shut and ears open for active listening. You have done this in communication. Active listening, you have done in communication. You have also done non-verbal communication about body language. Therefore, you have to create that platform for them to vent. And it is possible that this vent will last a couple of hours, maybe 3 hours, maybe 4 hours, maybe 2 days, maybe 4 days. It doesn't matter. The mediator's job is to shut up and just listen. And what does this mediator do when he or she is listening? It's not a counselor. It's not a venting session for the sake of venting. This venting is to be used to understand the core of conflict and dispute. There is data coming. There are tons and tons of data that will come to you on the venting platform. It's for the mediator to sort them out, see which leads to the core of the conflict, which leads to the dispute, and move on. Then the third session, the third objective is to enable the disclosure of confidential information. Now, we have done confidentiality when we did the last class. In the joint session, it is possible that parties who are actually before you will not be comfortable giving you confidential information. Now, what is confidential information? It is information that I, in my knowledge, believe can be used against you to gain some advantage. It's a sense of power. Therefore, a party who knows that the defendant has multiple properties but is pretending not to have properties knows that this defendant has properties. Now, he does not want to disclose that in the joint session. The private session will enable him, or you will enable him, to disclose that information and to be classified as confidential information, which means that you shall not disclose that information to the other side. Now, can you imagine what happens when you get confidential information and the party who is giving you that information is protected from disclosure of that? What is the environment? Can anyone quickly tell me what is the environment? What is the result of this?
So confidence, sir.
Yes. Confidence in whom? Which? What? Where? In confidence in?
Sir,
Mediation, sir. Then the
Confidence in mediation, and more important, confidence in the mediator.
yeah,
Yes.
mediation.
Yes. It's a one-to-one relationship between a mediator. Therefore, the more confidential information that comes to you, two things happen. It enables you to get to the core of the dispute or the core of the conflict, and from there find out in which direction shall I go to resolve the dispute. The second thing that happens is it creates a bond between the mediator and the person. Therefore, even information that they would never have disclosed to anybody may come to you. That is one of the purposes of private sessions. Then you have to identify and understand the interests of the parties. What is the difference between position and interest? Quickly, go back to last class. Fundamentals of mediation. It identifies, or two things I told you. One, it identifies conflicts and dispute. Other thing I said, it differentiates between positions and interests. I can see everybody going back to their on their computer, going back to the last class, but it should be here by now. Quick, I gave you alert. I gave you 4 days notice, man. I gave you 4 days, guys. All right, no chocolates for this one. We remember we talked about interest and position. Position is the stand that is taken, is what I want. Interest is what I need. So a party to a mediation dispute may be wanting 100 crores from the other party. But when you get this confidential information, it may turn out that the need is only 20 crores. So it is only in the private session that you're able to identify and the interest of the parties. If you ask questions about what the interest is or what is it that you really want, if you ask those questions in the joint session, you have destroyed mediation because the other party will walk out. Therefore, as a part of the confidential information disclosure, it is open to you, but through a process of refined questioning to understand what is the interest and what is the position. Then it also enables you to assist the parties in understanding the realities of their case. It is the best example I can take in this case is of matrimonial disputes. I am very reluctant to usually talk about it, but this is the best example. There is a law outside in the United States and in the West where every asset that is purchased after marriage is deemed to be matrimonial property, and there is a division down the line. Now, in a mediation that you're doing, this lady, the person comes and says, sir, 50% is the law. I'm entitled to 50%. Now, your job as a mediator is not to tell her, no, you're wrong, man. You're talking on, no, that's not the law, because you're not a legal advisor. You therefore assist the parties in understanding the reality of their claim. How actually do you think you can get this? How real is your claim? And this is done by a process called reality testing. This private session gives you the option to talk, option to convince them, because there is nobody else around. It's only the party, you and the counsel, if at all, otherwise no. And finally, it establishes a relationship of trust in the mediator. Then, the other objects of private session, you have to move parties towards creating options. Now look at where we have got. We have made them sit, they are comfortable, you have welcomed them, they have agreed that it's a party-centric process, you have listened to them, you have finished with the joint session. Now this party is venting with you, giving you information, loads and loads and loads of information, you're sifting. Now you have to move the party from venting. That party has you moved to thinking about, how shall I resolve this dispute? It has to move from what to how. That is the job of, that is the object of a private session. How that is done is, again, by communications, using the right techniques, using the right questions, but you move the parties away from the position towards their interest, and thereafter, a simple question like, how do you want to resolve this issue? One of the most brilliant questions actually works in a private session is, do you want to be a part of the problem or would you want to be a part of the solution? Do you see how the avenues open up? Now, if he or she says, I want to be a part of the problem, you already are the problem. If you want to be a part of the solution, would you tell me how you want to solve the problem? That what has happened is the interest has been established. They have told you what their interest is. Now you're saying, how will you want to achieve that? That's one object. Then you persuade the parties to evaluate the options. It's not enough if I throw ideas. You have to persuade the parties in the private session to evaluate the options. There may be 1, 2, 3, 4, doesn't matter how many. But a mere throwing of an option is not adequate. The person has to evaluate. Now remember, the fundamental mistake that some of mediators make is, the mediator begins to evaluate the options. No, that is a no-no in the mediation process. A mediator's job is not to evaluate. A mediator's job is to get the parties to evaluate. Then, to understand the pain points and emotions of parties. This is one of the trickiest situations in the mediation process. If you have undergone similar pain points, it becomes far easier for you to understand the emotions and the pain points. But the danger there is you slip into sympathy and not empathy. The danger there is that you will begin to find solutions that you think are proper because you have been through the same emotions. So it's easier, no doubt, but the dangers and the perils are far more substantial. So in the private session, therefore, you understand the pain points. What is it that is bothering you? There is something called non-violent communication that Dr. Marshall has talked about. I don't know whether it was done in the communication center. Now that proceeds on the basis that when one says something, when one says I'm angry, then that emotion represents the lack of something in that person. What is my need? Why am I showing I'm angry? Why am I saying I'm angry? There is some unmet need within me. Therefore, let us identify that need. Now, to understand pain points is a tricky thing. You have to be sensitive. You have to be understanding. You have to be patient. All these are qualities that you'll do later. So a private session is intended for that purpose. And then to create a ground for creative options. Now, look, let's suppose a solution is suggested in a joint session where all the parties are present. It is possible that the other party may turn around and say, don't be stupid, man. That's a pretty stupid proposal. In a private session, that cannot happen because a mediator keeps his mouth shut. Whatever comes in the private session has to be absorbed by the party, by the mediator. So at the end of it, irrespective of the stupidity of the suggestion that I may make for resolution of the dispute, there are no judgments passed on that, which otherwise may happen in a joint session. And therefore, we use the private sessions for only ground options. Now, what are the techniques that we use? Reaffirming confidentiality is one of the best techniques that you can use in the mediation process. Continuously reaffirm confidentiality, saying that we will not reveal this to any person. You give me confidential information, I will retain that, and unless I have your permission, I will not reveal it even to the other side. Reality testing we have done. Then using effective questions. Now, yes or no questions are a no-no in the mediation process. Yes or no is available in cross-examination in a court. But effective questions in mediation simply means drawing out information from them. Would you please tell me something more about this? How would you like to tell me this? Would you please give me some more information on this? What would you like to do? All these technicalities, these language technicalities will have to put into use. And what do we mean by an effective question? An effective question is not how many cups of coffee did you have this morning. An effective question is something to which a reply is generated, and that reply helps you or gives you information to strategize the movement of the mediation process. All your gupshup you guys do in your coffee shops and on your college benches and all that, that is not effective questions. Whether you like Sanjay Khan or whether you like Amir Khan or whether they're divorced, how much money they're paying, all that is not effective question. Effective question is, what are you feeling in this situation, ma'am? What is the solution you want? Why are you feeling the way you're feeling? Can you tell me a little more about what happened on that? Effective questions must elicit a response, an equally qualitative response that gives you more material to move forward towards a resolution of the dispute. Again, that is a huge subject. It is not possible to cover it right now, but I can only tell you that effective questions are different from non-effective or nonsensical questions. So try and understand what is effective questions and ask so that you get material back. And then the techniques that we use is called BATNA, WATNA, and MLATNA. Suppose parties are not moving towards a resolution, then the first one is BATNA, which means it's the best alternative to a negotiated agreement. It is up to the mediator to make them understand, all right, you don't want to settle, it's excellent, no problem, we are not going to force you, it's your dispute. But what do you think is the best alternative to this negotiated settlement? The idea is to get the parties thinking of alternatives. Next, WATNA. What is the worst alternative to a negotiated agreement? What is the worst that can happen? Are you aware of what can happen? What is the best if you settle? What is the worst that can happen? Maybe he will say, I lose my property, I lose my wife, I lose my children, I lose custody, I lose everything. But it's up to the mediator in private session to make them aware of what the worst that can happen. And MLATNA, as usual, is in between. What is the most likely alternative to a negotiated agreement? And that is the place where you get to negotiations and settlement. One is a clear negative, one is a clear positive, the other is somewhere mid-ground where you begin to get them to think about how can I move forward towards a resolution. Then the other techniques we use is brainstorming. Now, this presupposes that the parties have brains. I mean, brains who are willing to think. Most parties who will come to mediation say, sir, you tell me what is to be done. I will do. Not allowed. You're not an advisor. Now, the brainstorming is a technique where every idea, however stupid, idiotic, meaningless is stated, is put into some kind of a box. Figuratively, it's in a box. It's noted without judgment about what is viable, what is not viable, what could be done, what could not be done. Imagine a box, put all these ideas into the box, and thereafter evaluate through a process what is possible and what is not possible. And finally, the technique one sometimes we use is subsessions. If there are 3-4 parties to a dispute, you could have subsession with one party, then with the second party, then with the third party, then with the fourth party, and so on. That depends on the skill and the assessment of the requirement by the mediator. Then you come to the last stage of mediation, not the last stage, second last stage, settlement. If there is a settlement, what should be the content of a settlement? First of all, a settlement should be legally enforceable within the parameters of the law. The content should be clear, specific, understandable, and not Shashi Tarorish again in language. Neither extraordinary legally language. It should be something that the parties understand, for which you need drafting skills. Language skills and drafting skills are absolutely necessary. Now, when a settlement is signed in court annexed mediation, that settlement is signed only by the parties, not by the mediator. It is signed by their counsel, and it is sent back to the court. Court will look into that and find out, examine whether it is within the parameters of the law, whether it is legally enforceable, and if so, it will accept that settlement. And once it accepts the settlement, it becomes a decree of the court. At the stage of drafting skills and contents is another separate subject. Then, irrespective of whether a settlement happens or a settlement does not happen, the last stage in mediation is what we call a closing statement. It's like a vote of thanks, except that in any formal vote of thanks, whether you like it or not, you keep thanking everybody, saying you've taken so much time off, sir. You made an extremely brilliant contribution today, sir. The usual nonsense goes on. But in a closing statement in the mediation process, the purpose is 2 or 3. 1, to genuinely and warmly thank the parties to the mediation for having attempted the mediation process. Now, you can't say that with a sad face. You can't show disappointment when you say that. I mean, you can't be saying, sorry, it's okay. You didn't do it. No, we'll see next time. Thank you very much. Bye-bye. Go. No, not allowed, not allowed, not allowed. There is a cordiality. There is a business-like approach. All right, it has not happened. Doesn't matter. We are grateful that you participated. We are grateful for your proactive participation, and also alert them to the fact that just because this settlement has not happened, this mediation has not succeeded in a settlement, alert them to the fact that it does not bar them from a second settlement mediation process. There is no res judicata or estoppel in the mediation process. You can do mediation as many number of times as you want. So the purpose is, number 1, to reinforce their faith in mediation, to thank them for having participated in mediation, to remind them that they could be at the mediation process at any time or any number of times, and fourthly, and most important, that there are no judgments passed against any of them for not having resolved this matter. It has to create a sense of confidence in them. And the role of the mediator here is the most critical role. When you close a chapter, whether it is successful or not, the manner in which you close that event, the manner in which you close the chapter must be similar. You cannot be permitted, you are not permitted to distinguish between talking to a person who has settled and a person who has not settled. It is the same warmth, it's the same confidence, it's the same cordiality. You will find it difficult, mediators find it difficult, because at the end of 16 hours or 18 hours of mediation, if it does not end in a settlement, it affects the ego. The mediator begins to feel, come on, man, 18 hours of stuff I have done, and you are now saying you don't want to settle. Get lost. The first response is that. Therefore, a mediator has to curb those responses. His personality is different. You'll do that in a later class, I hope. So we close this mediation at that stage. And if a mediation does not result in a settlement, in court-annexed mediation, you send the cases back to the court without telling the court why the mediation did not end in a settlement. The court will never know whether the plaintiff, because of the plaintiff or because of the defendant, why it happened. The court will never know. There is no apportionment of blame at all in the mediation process. So they came in unhappily. If the mediation process has happened the way it should happen, they go back happy with the process, but not with the result. It's a job of a mediator to create that confidence and happiness in the mediation process. All right, do we have any questions now? I'm glad I finished early enough before I go to the last slide.
Yes, sir, we have one question from
Yes, I can see
Paul,
some 15 plus chat 16.
Paul Tachang. It's if mediators are not allowed to give legal advice, then how can parties make a meaningful agreement without knowing the law?
What are their advocates for? In court-annexed mediation, they're always represented by advocates. It's their business. And if they have a bad advocate, then bad luck. Once a mediator begins to give legal advice, or even if he says that the Supreme Court has approved this, this is the decision of the Supreme Court, you have lost neutrality. You have lost partiality. Therefore, the object of a legal advisor in court-annexed mediation, most of them are accompanied by their advocates. Now it's up to the advocates. However, when I talked about a subsession, if you find that what is being stated is a complete contradiction to the existing law, it is open to the mediator to have a subsession with the lawyer alone and there ask, how, Mr. Counsel, are you saying this? Are you aware of this law? Are you aware of this decision? That is permissible in a subsession. But you can't do it in the presence of a party because then you're destroying the relationship between the party and the counsel. So you can use subsessions, you can alert the party, you can alert the counsel about, I mean, you can't tell him you're a fool, you're talking nonsense, this claim is ridiculous. The same kind of communication techniques that you use, including reframing techniques, are to be used with the advocate. Remember, advocates are an integral part of the mediation process. Without the advocates, you will not succeed in the mediation. For the simple reason that the first point of contact for a client is his advocate, not you. Until the advocate says, yes, the party will not sign. Therefore, there's an integrative process that happens. You have to take the advocate along. That is how you will get the advocate, the legal advice to them, if at all. Yes, ma'am. Have I answered the question? Will you please tell me whether I have answered the question?
Thank you, sir. Sir,
Yes, sir.
I mean, Azim has raised her hand. You can ask your question, Amin.
Wait, can I come back to share later after I answer these questions? All right, now it's easier this way. Yeah, who is asking the question?
Sir, it's Aman. I'm from Pakistan.
Where are you? I can see you.
You cannot see me. Yes, can you see me now?
There you are. There you are. Yes, I mean, yeah.
Yes. Yes, my question is basically kind of procedural in nature. In the previous session, a question was asked, can we say that mediation has failed? When we go into contracts, we see there is an alternative dispute resolution clause where the last resort of the parties is basically arbitration. There are some pre-arbitral steps written in there where you go, the parties write that before going to arbitration, they'll go into mediation or negotiations or conciliations. And the last resort is arbitration. So there are some pre-arbitral steps. Then you do not get a solution from those pre-arbitral steps. Then you go into arbitration. So in that sense, can we say that mediation has failed?
Okay, good question, but let me give you an answer to that. There are two schools of thought, fundamentally. A group of people continue to say mediation has failed because it has not resulted in a settlement. But mediators like me that say that no mediation ever fails. Why? Because mediation is not only intended to resolve a dispute, it's also intended, as we saw earlier on, to create a channel of communication between parties. It opens up communication channels. It enables the parties to understand each other's perspectives of the issue, of the problem. Therefore, to judge and say that a mediation has failed because it has not resulted in a settlement, according to me, is incorrect. But these are individual views again. There are institutional mediations in India also, in Bangalore, which determine the success of mediation only by the number of settlements signed. It's an individual view, really. If you say that mediation, every mediation which results in a settlement is successful, everything else is not, I would contest that by saying in the mediation process at a table, there are two parties facing each other. They're talking to each other. They're negotiating each other. The deal may fail because I don't agree with the terms that you're offering. So to that extent, we have established a common platform of communications. That is how I would answer that. Maybe it is not an adequate answer for you, but it depends on the view.
And after the mediation, when the parties are going into arbitration, can that mediator act as an arbitrator as well?
You tell me. We did in the principles of mediation that we did last class, we did neutrality, we did impartiality. You think he can? He or she can? You tell me.
The opposing party can object it?
Forget the opposite party. You have done mediation in a case between me and Pushp, or the boss. Now that mediation, according to you, fails. According to me, doesn't end in a settlement. Can you be the arbitrator? Doesn't matter. There are no right. You don't worry about the answer. Yes or no is the only answer you can give me. Oh, I think she's lost connectivity. All right, let's move to the next question until she is connected. Yeah, anything else?
Yes, sir. One more question. How does personal injury mediation work?
Personal injury mediation.
Yes, sir.
Tort. You mean torts? Pavan, are you talking about torts?
No,
Yes, sir. Yes,
Pavan
sir.
gave-
Torts. Okay. Do you believe that it can work or cannot work?
How does personal injury mediation work? The question is only this much.
Yeah, so
Pavan Dev
he-
Singh, if you're here, you can clear your question again.
No, he has said yes. He said he's talking
Okay.
about torts.
Okay.
Under tort.
Yes, under tort. You tell me, what is a tort? Tort is a civil wrong, correct?
Yes, sir. Yes, a tort is a civil wrong.
It's a civil wrong.
It's a civil wrong. From civil wrong flows what? If I accuse you of a tort, if I accuse you of a civil wrong, if I accuse you of a civil wrong or a tort,
Sir, liability comes.
what can happen if I take you to court?
Remedies,
Only thing, damages can be claimed.
Damages. So it's a money claim. So it's a money claim.
Compensation.
So it's a money claim. Yeah, compensation, damages, money claim. What is the difference between a money claim? Cannot a money claim be mediated?
Yes, sir.
Yes, we
Can be,
can.
sir. Yes.
Yes, it can be.
It can be. Can or cannot a motor vehicles case accident claim be mediated?
Yes, sir. They will
Yes,
maintain
sir.
it.
Lok adalats are doing it. Mediation is doing it. So wherever there is a money claim, there is nothing that comes in the way of a mediated settlement. Are you satisfied with the answer, Pavan?
Yes, sir. Yes, of course, sir. Yes, sir. Thank you, sir. Thank you so much.
Yes, sir.
Okay.
Thank you very much.
Yes, Samriddhi, next.
That's all, sir. We have no more questions left.
Where is, has she come back? Let's see if she has come back.
I'm back, sir. I'm back.
No, not you, not you. There was a question I meant.
I thought.
नहीं, आपको इतनी जल्दी थोड़ी छोड़ने का है.
Okay.
All right, then let me get back to my screen. Has she come back?
So,
Yeah. Is Ayman there? Has she come back? All right, we'll come back to it later.
I have a question here.
Huh?
Sir, when you say that you cannot bring law when you're doing mediation, is that what you said, sir?
No, that's not what I said. I said that the principles of law that a court applies in adjudicating matters are of no relevance to me in the mediation. If you go to a court and file a case against a person of infringement of, let's say, you have encroached on my property, the court, all that it can do is to see, does the law provide you this right? Have you actually violated that right? If so, do I decree the suit or do I dismiss the suit? This is all that the court can do?
Yes, sir.
Yes. When it comes to mediation, it is possible to work out a solution without reference to that law.
Yes.
Saying that he can, in a private session, admit that, yes, I have taken 4 inches of his property. Yeah, I know I admit it, but I'm going to fight the case. In the court, I have said I have not encroached, but it is so. I will pay him some compensation. That is not permissible in a court of law, because the court is bound by either decree or a dismissal. Is that an adequate answer or no?
Yes, sir. Yes, sir.
All right. Okay, let me get back to this. Now comes the troublesome portion, the troublesome slide that I'm going to show you. And it's going to be
sir, yes.
All right. Now, this is the...
So before you proceed, sir, one question, sir. Once you're through with the, once you really sit and, understand what the parties really want to do and, what they are up to. So you are actually, I was the one who asked about the facts of the thing. Okay. So, when you actually, you kind of see the bigger picture. When you actually have a lot of multiple sessions, you see a bigger picture of what is both the parties. Probably the other party would not say, but you would be able to see, okay, this is what is heading to. So when you're actually seeing the entire thing, one person is adamant, the other person is, both the parties would be adamant. So you are actually seeing the facts of the case now. You're seeing the bigger picture. That's what, and then, would not that be a better option to mediate? You are in a better position to mediate.
Okay, that's the broadest question I've had so far. All right, let's see how many components are there. My first observation would be that you have said you will know what the parties are up to. We are not concerned with what the parties are up to. Not my job. Parties may be up to anything. One party may be up to finding out a plan to kill the other man or take away all his property. So we are not concerned with what they are up to. We are trying to understand what they are projecting to you. Now there is, for example, there is a mediation called narrative mediation. Now in narrative mediation, it proceeds on the fundamental assumption that what I am telling you now is not actually what happened, something else happened. And I, as a mediator, am concerned with what actually happened. So when I say facts, the question goes to, was it or was it not? Did it or did it not? These are not relevant to the mediation. When you look at the bigger picture, you're not looking at the did it or did it not. You're looking at perspectives that have formed the thought process in the mind of one of the parties. A party may have 10 reasons why he's saying what he's saying. Now, you as a mediator, we as mediators are not concerned with why he's saying it, whether it actually happened or did not happen. If so, when did it happen? How did it happen? No. We are proceeding on the assumption that one party is seeing this in this manner. The other party is seeing it in this manner. How do I integrate these two perspectives? Now, in the private session, in the reality testing, it may be possible for you to elicit what you consider the fact and some other perspective of the party. There is always a difference between perspective and fact. because there are no empirical facts that we are dealing with in mediation. Please remember, we are dealing with perceptions. And when we talk about perceptions, the question of fact as we understand it in law doesn't exist.
Munima Champi.
Okay.
Leave meeting.
There's somebody, video is on, audio is on.
Please mute your audio. Who is this?
Have I answered your question, ma'am? I'm not sure.
Yes, sir.
You have. All right.
Sir,
Do we have any more questions?
Sir,
Ayman has come back.
Ayman is back, sir.
Yes, Ayman, come tell me, where were you? Have I answered your question?
You have answered my question. A last question I asked, and somehow I faced connectivity issues.
Please ask. Please ask. I've given you the screen.
Yeah. The question was, can a mediator again act as an arbitrator?
Right. You tell me. I had asked you a question. I had answered that question by asking another question. Dispute between the boss on the screen and me. You go through the mediation process. No settlement. According to you, the mediation has failed. According to me, the mediation has not failed because I have taken her telephone number and I'll take her out to dinner tomorrow. That much I have achieved in the mediation process. Done. Now, in that dispute, can you be an arbitrator? If so, why? If not, why?
I would not say that mediation has failed. I would say there wasn't any settlement through mediation.
Perfect. I didn't think it was so easy to convince you, but I have convinced you. All right, done. Now, can you be an arbitrator?
I think I can be an arbitrator because as a mediator, my role was totally neutral. And again, as an arbitrator, my role will be neutral.
Now you are an arbitrator. You sit in arbitration over this dispute between me and Push. Do you or do you not have confidential information from both sides with you?
Yes, of course, I have the information. But before then, in the process of mediation, I acted as a mediator. And from mediation, I have some confidential information from a party.
Yes.
So
what? Go ahead.
But that shouldn't come in front of me as an arbitrator when I'm
very nice. Very nice. Do you agree with me that there is a huge difference between should and what actually happens?
Yes, of course, I will agree with you. Yes.
That's all I'm saying.
Because the mediation process has ended.
No, mediation process has ended. There is no process by which you can eliminate or delete that confidential information from your brain. You can't hit the delete button. It is there. And in the mediation process, based upon that information, in all probability, you would have already formed opinions about what is right, what is wrong. This should not have happened, that should have happened. But you have curbed it because mediation does not allow you to move forward in that. Now you move into the arbitration process. You're in a judicial adjudicative process. You say it should not come in the way. Perfect. Agreed. What is the guarantee that it will not?
I cannot give a guarantee because I have formed an opinion as well. Yes. It's true that I have an opinion.
Therefore, we say lay down the law that in the interest of fairness, in the interest of transparency, in the interest of neutrality, in the interest of impartiality, a person who has knowledge of the mediation process shall not arbitrate. Please remember, in the arbitration, shall not arbitrate. Because in the mediation process, in the arbitration process, you will be given information that they think should be given. You have no scope to get into a private session and ask for more information. They will give you facts as understood by the Indian Evidence Act to be appreciated by you and give your award. Now, if you have already mediated, you have gone through the process of individual private sessions, loads and loads of information about their intent, why they did what they did, admissions may have been made. And it is not possible for a human being to be so totally neutral and discard all that earlier information. Maybe you are one of those who can, maybe I am, but the law says as a rule, no, you will not. That is where the award will become biased, could become biased. Yep, have I answered?
Yes, sir, you have answered well. Thank you so much.
Very good. All right, let's come to the last screen, guys. We have, I don't think we have time. Mr. Tankachan, it's 7:30.
No issue, sir, no issue.
No issue, all right. All right. Okay. Let's look at this. The other thing that the screen sharing has stopped. Why has it stopped? Why has it stopped? All right, let's take this. We have looked at the process, which is sometimes called stages. Now let's apply all the knowledge that we have learned in class 1, class 2, class 3, and now class 4. The first stage, according to some people, is understanding the problem. Are we understanding the problem, or is a mediator trying to do something else? Understanding what? Quick answers.
Perspective, sir.
Huh?
Understanding the perspective, right?
Perfect, absolutely. Now, what does understanding the perspective mean in terms of all that we have told you?
Understanding the interest of the parties, both
No,
the parties.
you move to the
their
next slide. No. You very cleverly, you move to the next slide. No, I'm not here. I'm not here yet. I'm only here yet.
What is he thinking about the case, sir? What is he thinking?
Understanding the problem. Does it mean that you're thinking of facts? Does it mean when understanding you're thinking of issues? Or are you talking of problems? That question has been answered by saying you're thinking of perspectives. Correct? Now, what do you mean by understanding the perspectives? Let's change this word problem to perspectives. What is the meaning of understanding? What does it require?
So what kind of remedy they are expecting?
Now, you are doing the understanding. Yes, that will come much later here. But I used a specific expression in the last class. I thought you would have caught it. Understanding the perspective requires a fundamental state of mind, which will require you to accept this also is, as opposed to this ought to be. When a mediator is required to understand the perspectives, it means the mind must be open to contrarian views, to multiple experiences, multiple circumstances, and therefore accept the fundamental principle that this also can be, rather than saying this is the way it ought to be. And when you say I understand the problem, as rightly pointed out, it is not the problem, it is the issue, or it is a perspective. The party see it as a problem. The mediator cannot see it as a problem. The mediator has to see it as a perspective. All right, next. Deeper understanding of needs and interests of both parties. Where have you got the basic information? Tell me. We are talking about deeper understanding. Very nice. Very good. Very good. Now you have got the deeper understanding how?
By conducting the private meeting with the party.
Okay, all right. You have got the first information in the joint session. All right, you have some idea of what it is. Excellent. So you deeper understanding of the needs and interests of both parties is done in the private session. How do you do it in the private session? How? We have just finished that slide.
Sir, open questions, sir. And
Yes. Anybody else? Go on.
By giving the confidence to the party that he should know everything, so that only he can be able to solve his interest. Like, both the parties have their personal interest. So both should be in win-win situation. So that way he will create a confidence in the party. No,
I'm asking, how will you understand deeper understanding of needs and interests? How will you do that? You're doing it in a private.
questions to the parties. Only, sir.
Sorry, there's a male voice which is giving me the correct answer. What is that? Who said that?
By asking questions to the parties and encouraging them to speak more about the issues.
Very nice. Asking questions.
Yes,
what kind of questions?
Effective questions.
Effective questions, sir.
What does it mean? What is prohibited when you ask effective questions?
Interrogation, investigation, they are all prohibited.
Kind of questions.
Yes and no
Judgmental.
questions.
What, where, when.
The famous W questions. Please remember who, why, when, where, what. These are called the famous W questions. So you do not ask those questions. Can you give me a sample of how you will ask one question? Anybody? To understand the interest?
Would you like to give us more information about this issue?
Good. Is it allowed is it allowed in mediation to say, all right, now I've heard you, please tell me what you really want rather than what you've asked for?
Yes, sir. What he is expecting out of this mediation, or
Very
what
good.
is his interest?
So what would you actually expect from this mediation? How would you like to achieve it? Okay, done. Then we move to the next stage, defining the problem. Who defines this problem? Again, at this, remember the word problem. Is that word correct?
Again, this is
No,
perspective
sir,
only, sir.
I think so. Instead of stating that we define the problem, we consider the issue. That is the main contention that the parties have come to the mediation.
Very good. So you don't define the problem, you define the issue. Who defines the issue?
Mediator.
Perfect.
Mediator, sir.
Good. Very nice. Yes. The parties define the problem. You translate that into perspective. You have understood the perspective. The parties continue with the problem. You treat it as an issue because what mediation requires is to identify issues that need to be resolved. Okay, great. Creating options. Oh, sorry. Creating options. What does this mean?
In how many ways the issue can be resolved?
Who creates the options? You have read, you have done all that listening.
The mediator.
The mediator will give the option.
No.
Create the option.
Alternatives to negotiate, sir.
It's actually the mediator who facilitates the parties to move towards a solution. He can guide them, but he cannot suggest any solution or option.
Correct. Which is why this slide was put this way, creating options. Just the keyword. A mediator cannot create options. The mediator, through a process of communication, understanding the needs and interests of both parties by defining the issues involved, enables the parties, facilitates the parties to think of solutions and therefore create options. Fundamentally, a mediator, if he starts giving options, he becomes an evaluative mediator. He will become a non-facilitative mediator. Okay, that's creating options. Then evaluating options is the next stage. Who evaluates the options?
Party.
The
Mediator. Somebody said mediator. Wait. Somebody said mediator. Who said mediator?
So me, Sarita.
Okay. A mediator does not evaluate. If he does evaluate, what is the difference between a mediator and an arbitrator?
So he only evaluates in the mind, sir, but he will not tell. They themselves have to evaluate, sir. That's what I meant.
That is a very, very clever answer. An extremely clever answer. I mean, I'm amazed at how you're able to do this. I appreciate it. He enables he thinks about in his mind. Okay, I think about how good this option is, how good this option is, how bad this option is. Do I simply keep it to myself, or will it reflect in what I do next?
It reflects the next.
It might reflect.
So
it should reflect in your this thing.
Not it should, it will.
It will reflect in your mediation in the next.
One party says, you give me 1 crore. The other defendant says, no, I'll give you 50 lakhs. In your mind, you're evaluating this option of 50 lakhs. And according to you, you feel 50 lakhs is an excellent figure. You don't keep it in your mind. The next thing you will do to the other side is to say, why don't you think of 50 lakhs as a settlement? So you have translated thought into word.
But if the mediator translates his thought into word, does he not become impartial by encouraging the other party to accept whatever he is thinking?
No. All that he can do is to say, here is a proposal. What would you like to do? How would you like to respond? Would you like to? He cannot, by the process of communication, classify that 50 lakhs as a fair or acceptable figure. All that he can do is to say, look, this is what is on the table. Would you like to respond to it? Would you like to react to it? Would you like to make a counter proposal? Would you give me your opinion on it? Would you give me, what do you think of it? These are the final distinctions that are required when we look at mediation stages. I think I have exceeded times given by the boss, but I have actually a last slide which was questions anyway. So we will, anyway, because I've done it, you might as well have a look at it, right? Yeah, this was the last slide I had in my mind. Oh, there. Yeah. Thank you for listening. I think we have gone through all our the slides too, had lots of questions, and all that remains is to ask whether there are any other questions that remain unanswered. Please feel free to ask, be it about today's topic, yesterday's, last week's topic, class 1, class 2, class 3, or generally about mediation.
So Samriddhi, will you check? Have you checked the chat box? Has anything left?
No, ma'am, nothing is left.
So we are done, I think, Shiv.
No, I am done. I mean, it's up to them. I only hope they have understood something. I mean, it's been some value today of what has been given.
Of course, yes. They are. That is why they are asking many questions. They are applying the whole thing.
Thank you, guys. It's been a lovely experience. I have thoroughly enjoyed myself. No more classes for me in this juncture. I don't know, but today has been a brilliant experience. Thank you for being so vocal. Thank you for thinking. Thank you for giving opinions that lead and generate to some kind of discussion. Thank you. Thank you so much.
Thank you so much, Shiv, for the wonderful session.
So much.
And
thank you so much. Thank you.
Thank you so much, Shiv, for this wonderful session and illuminating, I would say, the intricacies of all the stages of mediation. And I would say that your depth of knowledge has always been very fascinating. And I'm sure that our students must have taken this gem of knowledge from your vault of experience today. And thanks to all the students also for making the session so interactive by pouring a lot of questions and by making it, an open discussion kind of thing. Definitely, you guys all asked very thoughtful questions. And I would like to wish you all the best from EMW. In the future, and in hope you get a great learning by attending our classroom series, which will be on. We will be, though I won't be meeting you again, most likely, and Shiv will not be there for at least this second series, but we will be always there in the third, fourth. We will be having so many series, and we will be meeting and catching up and keep on doing this good work with the help of the banner of EMW under Push Gupta.
One question.
Yes.
Push, have they been informed of the Gurukul thing?
Sir, I have shared with the students who have those who wanted to. So I've shared the details with them.
Okay. All right.
Yes. So you'll have huge lot of students entering Gurukul.
No problem at all. It's a great. If these are the kind of students, I would do it every day.
And Reema, Mr. Thankanchan are your permanent Shishya in that Gurukul classroom. He'll always be there.
Thank you, Samriddhi. Samriddhi, thank you for being a very effective moderator. Very well done.
Yes.
Thank you so much. Thank you so much. Today is Guru Purnima. So Guru Brahma, Guru Vishnu, Guru Devo, Maheshwara, Guru Sakshat Parabrahma, Tasmai Sri Guruve Namaha.
Wow.
Thank you.
Thank you so much, sir.
And congratulations again.
Thank you
for your 50 years today, Shiv.
Not 50 years, 50 years of practice. I'm 74, I'm 73. So
I have 50 years of practice only. I am 15, so I know you are much.
Congratulations, Shiv Kumar ji.
Congratulations, and it's a wonderful session.
Congratulations.
Really wonderful session. And your PPT is excellent, sir. Your PPT is excellent. No words.
Beautiful. Thank you so much. We appreciate your patience and interactively you are encouraging us to talk something, before we learn something, we are able to understand and come out of some solution.
Thank you.
Thank you so much.
So sometimes we have this hesitation of asking questions to someone who is so experienced, but we didn't feel any sort of hesitation. It was so interactive and
he made it so comfortable.
Yeah, he made it so comfortable.
You were all at ease with him while asking questions and interacting with him. He never made you felt that he's such a senior person and you cannot ask him. So it was such a
there is a Sanskrit saying, Yatha Shikshaha Tatha Guru. As the students, we learn from you. It's a great feeling. Thank you.
Yeah,
I mean,
from both sides. Yes, yes. You guys
honestly,
are also amazing. All the students are very, you guys were asking very thoughtful questions, very interactive, answering and not hesitating at all. When we all enjoyed, keep on having this kind of interest in the subject, then you will definitely get to understand it better. And I would say I can ensure that all our future teachers will be very good and they will be very helpful. You can ask them questions the way you were asking Shiv. So
yeah. I have been questioned so often in my life that I got used to it.
That is why your last slide was thanks for listening with big question mark in that last slide. So that's your life.
Yeah.
You love answering, so that's part of your skill. Thank you so much.
Thank you. Thank you, everybody. Good night.
Thank you.
Thank you once again.
Okay, take care.
Have a great weekend, everyone.
Bye.
Thank you, sir. Good night.
Good night. Have a great weekend, all of you. Bye-bye.
Thank you, sir. Good night, sir.
Good night.
So with your permission, let me sign off.